This particular case is dealing with judicial review. When it comes to judicial review case, it will be dealt under two grounds, mainly the substantive grounds and the procedural grounds. Substantive grounds means the case has been challenged with regarding to the law which was used. That means parties challenge that the improper law has been used when deciding the case. Procedural ground means parties challenge that an improper procedure has been used when deciding the case. Now we will consider the material facts. All the facts of the case will not be material. Only the facts which has been used by the judge to come up with the decision will be considered as material facts. Here we will consider who is Jackie and what sort of a condition is there with Jackie, where she lived and what is the connection between Jackie and the state. Further, we will consider the facilities which was given to Jackie and the incidents which has happened prior to her death, where she died and the reason why she died. Jackie is the claimant's daughter, who is an adult who lives in a home care which was supervised by Blackpool City Council, which is a state organization. Jackie was considered to be an adult who is vulnerable because she was suffering from Down syndrome. As a result, her mobility was deprived under Mental Capacity Act 2005. However, we have to note that she was allowed to go out of home care with supervision. She was always provided appropriate and timely access to her GP and NHS services. Since Jackie had a bad mental condition, Jackie was not capable of deciding what should be done for her own safety. Therefore, all the decisions were taken by the home care. Jackie was suffering from a bad health condition. As a result, home care called the GP and consulted. However, GP failed to make a home visit. Instead, GP prescribed all the medicine over the phone. And NHS also made a mistake because NHS had a paucity of advice. Further, ambulance crew failed to take her to the hospital since ambulance crew was not given proper information with regarding to her mental condition. And ambulance crew consulted the out-of-hour GP with regarding Jackie's condition. Out-of-hour GP made a poor triage without eliciting a full history of Jackie. As a result, Jackie was not taken to the hospital on that particular day. Following day, Jackie was taken to the hospital since she has collapsed. Jackie has died in the hospital on that day due to gastric ulcer and pneumonia. Now we will consider the questions of law. Here there are only two main questions of law. First, we have to consider whether Article 2 of ECHR is engaged for circumstances of Jackie's death. Second question of law is to consider whether coroner had made an error by deciding that there was no neglect and the jury is unable to decide whether a neglect has taken place or not. Now we will consider the decision. Decision was given unanimously. That means all the judges of this particular case have given a decision which is the same, and they have arrived at the decision using the same reasoning. As a result, all the judges unanimously dismissed the application for judicial review grounds. Now it is necessary to consider what are the detailed reasons for this decision. In order to understand the detailed reasons for this decision, first we have to have a good understanding as to the substantive law which need to be applied for this particular case. Therefore, we have to have a proper understanding as to what Article 2 ECHR is. When considering Article 2 ECHR, it is dealing with the right to life. Under right to life, state has two main duties. First duty is to make sure that the state will refrain from taking life unlawfully. Second duty is that the state will always have a positive duty to take steps to protect the lives of the people in its jurisdiction. This second duty, which is known as the positive duty, has been explained in the case of Osman against UK. As per that particular case, positive duty can be identified in two manners. First one is that the state should have a proper criminal law and a proper criminal justice system to protect the lives of the people in its jurisdiction. Furthermore, the second one is that state should make sure that the authorities are always taking preventive operational measures to protect the life of the people from third parties' criminal activities if their life is at risk. This second limb is now known as the operational duty of the state. This operational duty has been expanded by European Court of Human Rights from their own case laws. As per the case of Keenan and as per the case of Savage, this operational duty has gone beyond criminal liability. As per those cases, state will owe a duty of care towards a person who is even trying to commit suicide, only if the state is having a control over that person. For example, prisoner, immigration detainee, or even a psychiatric patient. Moreover, it has been further expanded from 3 more other cases, such as Judicial against Poland, Center for Legal Resources on behalf of Valentine, and Jacinikis against Latvia. As for those 3 cases, now it is identified that the positive duty will apply even for any death which has been resulted from egregious lack of medical treatment. However, we have to consider what sort of a person it was. Was it a detainee, or was it an immigration detainee, or a prisoner, or any psychiatric patient who was in the hospital? If so, state is owing a duty of care. That means state is owing their operational duty towards that particular person. Therefore, positive duty will now apply for people who are vulnerable and who is under the state control. Furthermore, those people were not capable of getting away from the danger posed by detention. If so, state has a positive duty towards this individual. If Jackie comes under these conditions, definitely Article 2 ECHR will apply for this condition. This scenario, Jackie is identified as a vulnerable person. However, we don't know whether state has a control over Jackie. And we don't know whether Jackie could be identified as a detainee. However, Article 2 will not apply for deaths at hospitals. Why? Because state's positive obligation in relation to hospitals and medical treatment are always considered to be regulatory. Therefore, as per the case of Lopez, if state has put in place an effective framework that compels hospitals to adopt appropriate measures to protect patients' lives, then regulatory duty is done. As a result, in order to consider whether Jackie is coming under Article 2 ECHR, it is necessary to see whether any regulatory breach of the hospital has been violated. If there is no breach of regulatory duty, then the positive obligation of the hospital is not breached. If so, state is not liable under Article 2 ECHR for Jackie's death, since Jackie died inside the hospital. Therefore, if state has made provision for securing high professional standards among health professionals and the protection of lives of patients, matters such as errors of professional judgment or negligent coordination among health professionals in the treatment of a particular patient will not be sufficient to engage Article 2. This was identified in the case of Parkinson, which was recently decided. As a result, now Parkinson case law is the authority to say that the medical cases will not engage Article 2. If so, we have to consider whether Jackie's condition is coming under any of these criteria. That means we have to consider whether the hospital had made all the provisions which is necessary to secure Jackie's life, and whether there have been any professional judgments which are errors or any negligent coordination among the health professionals when treating Jackie. In the case of Jackie, we have seen that all the events which has taken place prior to Jackie's death were considered to be individual negligence. For example, GP not making a home visit, paucity of NHS, then the ambulance crew was making a poor conclusion not to take Jackie to the hospital, and the poor triage made by out of our GP. All these things can be considered as individual negligence. If so, this case should fall under Parkinson authority. However, failure to provide timely and appropriate medical care to a person who is in need of it will engage Article 2, as identified in the case of Tyrrell. Therefore, now we have to consider whether Jackie was a person who needed timely and appropriate medical care, and that particular medical care was not given to her on time. If so, Article 2 will apply for this particular scenario. This means, in the absence of a systematic or regulatory dysfunction, still Article 2 will apply, but only if two conditions are met. First considered condition is state had assumed a responsibility for the individual's welfare or safety. That means now we have to consider whether state had assumed the responsibility of Jackie for her own welfare and her own safety, or for her own safety. In the case of Mitchell against Glasgow City Council, it was identified that who are the people whom we could consider as people where the state had assumed a responsibility. As a result, individuals who have been detained under mental legislations are considered to be people where state had assumed a responsibility. If that is correct, then Jackie should be considered here. But that itself will not be working, because as I mentioned you earlier, there are two conditions to be satisfied. The second condition is state had a close control over that individual. That means now we have to consider whether state had a close control over Jackie. For the answer for this question can be taken by going through the reasonings given by Lord Dyson in the case of Rebond. As per this case, it is considered that individuals who come under paradigm examples such as prisoners, psychiatric patients, immigration detainees and otherwise are people where state had a close control. If so, now we have to consider whether Jackie is considered under these paradigm examples or not. . As per above reasoning, now we can say Article 2 will engage in the absence of either a systematic dysfunction arising from a regulatory failure or a relevant assumption of responsibility in a particular case. This means the entire reasoning for the decision of this particular part of the case is based on this what I have mentioned just now. This will actually be the 1 ratio for this particular case. When applying the material facts to the reasoning, we can see all the complaints made by the complainant was only individual negligences, such as the GP's failure to make a home visit within 2 hours, poor triage of the out-of-hour service GP, the paucity of advice given by NHS 111, and the way that the ambulance crew behaved. All those are individual negligences, which will not actually be a violation of positive obligation of the state, as per the case of Parkinson. And when considering the other 2 criteria, we can see that the judge has identified that mere being mentally incapable and mere being under Dawes category is not an automatic reason to consider under paradigm examples, because here we can see Jackie was not a person who was imprisoned or detained. Jackie was all given freedom to go out of the home care, but only thing is she has to move out only with supervision. But that doesn't mean that Jackie is an imprisoned person or a detained person. Therefore, that criteria also failed. As a result, now we can see that Article 2 should not apply for this particular case. And moreover, when we consider the procedural grounds, we can consider that judge has mentioned there is no irrationality or any error of law which was made here. And these procedural grounds will be considered further in our next part. Therefore, we can consider this as a medical case, and jury would not safely find that Jackie's death as a result of any actions or omissions of which the state would be responsible. As a result, Article 2 ECHR will not engage for this scenario. Thank you. We'll meet you all to discuss the second issue of law as soon as possible. Please watch my second video.